We are outside the presence of the jury. The attorneys and Mr. Miu are present. At the beginning of trial, Mr. Nelson submitted a letter with a motion of sorts objecting to a portion of Deputy Thomason's body camera footage. Mr. Anderson, you've received a copy of that letter?
Yes.
Who's arguing the motion?
I can.
Okay. Are you intending to play the portions that he's objecting to?
Yes.
All right. What's the basis?
So Miranda only applies if it's a question likely to elicit an incriminating response. They said, you're under arrest for homicide and attempted homicide, okay. And he says, okay. That's it. They're not interrogating him. They're not asking him questions about the incident. They're just asking if he heard what they said. He says, okay.
Mr. Nelson?
Respectfully, I disagree with that recitation of the facts. It's a very short video, and I don't see any reason why Your Honor couldn't watch it right now. They do tell him he's under arrest. They do say, okay, and he doesn't respond. They then say, we're next going to essentially bring you to the police station, and there's going to be an investigator there to speak with you. And then they ask the question, all right, and it's to that question that he responds, okay. So it is not in response to the information that he's being charged with a crime. It's in response to a question about what happens next and where you're going to go.
So you're objecting on Miranda grounds?
I'm objecting on relevancy, and I'm also objecting on Miranda.
Okay. What's the relevance?
So he's acknowledging he's hearing what the officers are saying, and then he acts surprised in his interview, like he didn't know somebody died. There's a lot of that's going to be argued in closing. The chaos at the scene, all the victims there, everybody else seeing what's going on. That will be one of our arguments. But then also, he's told he's under arrest for homicide, and then told there's going to be somebody's going to talk to him. He acknowledges he hears them,
Okay.
and then he acts like he's surprised in the interview.
Judge, if I may?
Yes.
If the state wanted to introduce testimony from a law enforcement officer that said, I told X to Mr. Miu, I think they get to do that. It's the response that we're worried about. And so if they call the officer and the officer says, I told him he was under arrest for X and Y, there's no, I don't think what happened next is the cutoff, but I think they get to do that, and I think that addresses whatever relevancy there is to it without having to get into Mr. Miu's response.
I guess I don't understand what the prejudice is.
By the same token, what's the relevance?
I think I just outlined it. That's our position.
There's
haven't.
the prejudice. I mean, they don't want that to come in because it's obviously harmful.
But why? I haven't heard it articulated why it's prejudicial. Not wanting it to come in isn't prejudice.
So a couple of things. I don't have to prove it's prejudicial. You have to prove it's relevant. If it's relevant, I can then argue it's unfairly prejudiced. That's not my argument. I'm saying his answer is not relevant. If you want his answer in, which is what you, I think, are trying to do, that's a different relevancy analysis. And first, that's a Miranda violation. Second, I think his answer is, the probative value is outweighed by the probative value of his answer is outweighed by the danger of unfair prejudice. So the question, I think, really is, what's the relevance of his answer? Not his being told the information. We get that. We concede that.
So if it has any tendency to make it more or less likely, it's relevant. To be excluded, this prejudice has to substantially outweigh the relevance by statute. And I still haven't heard an articulation on how it's prejudicial.
Okay, let's turn this a different way. What about the Miranda analysis?
It's not a question likely to or meant to elicit an incriminating response. It's just.
But you're using it to prove he's guilty. So isn't it an incriminating response?
It turned out to be, but at the time they're just asking if he heard. But it's only useful to the state because then he later acts like he didn't know somebody died.
just lastly, Judge, again, his answer isn't to the information about his arrest. His answer is in response to they're telling him they're taking him to the police station where he's going to meet with an investigator.
I saw the video once during motion practice, so I have a vague recollection of the sequence, but if it's short, let's take a look at it so I can make a fresh decision. Tell us when you're ready.
Do you have the timestamp handy, Brian? All right, I'm ready.
Yep. Last I heard was nothing is going to poke me, prick me, stick me, hurt me in any way. Absolutely. So right now you're being placed under arrest, okay? You're being placed under arrest for a homicide and attempted homicide. And that's all we're going to discuss with you right now. More than likely an investigator will come and talk to you at the jail. All right?
Okay.
Further thoughts? Anything else?
No.
All right. The video, in my judgment, has evidentiary value to a point. If it is the state's contention that Mr. Miu acted like he didn't know what was going on or acted surprised during the jail interview, I think it's relevant to show that he had advanced knowledge about the circumstances of his arrest. So clearly the portion of the video where he's being taken into custody, the deputy tells him the reason for it, I think is relevant for that purpose. We can see on the video, Mr. Miu appears to be alert. He appears to be paying attention. So I think that will feed into the state's argument. That much is relevant. The portion where Mr. Miu acknowledges what was being said had to do with the investigator coming to see him. That does not have the same relevance that you're describing here, because it has nothing to do with Mr. Miu being told about the charges. He's being told about something else, which is not relevant to the jury's task. So I'm ruling portion of the video after the reason for the arrest is announced is irrelevant. I don't know what mark that was in the sequence, so we'll have to go through one more to identify exactly the point where it's going to stop.
Okay. Oh, can we get the screen?
Yes.
Simmons under arrest? Have we done that yet? Last I heard was nothing is going to poke me, prick me, stick me, hurt me in any way. Absolutely. So right now you're being placed under arrest, okay? You're being placed under arrest for a homicide and attempted homicide. And that's
236.
Obviously, if it's a second or so off, as long as I'm not getting the part that Your Honor said,
Well, continue playing. Let's see how close it is.
That's all we're going to discuss with you right now. More than likely, an investigator.
So
236?
236 is the spot. All right, anything else we need to address?